Department of Health and Human Services. As part of our monthly Small Business Acquisition Learning Series, we've asked the Small Business Administration, specifically Kenneth Dodd, Director of the Office of Policy, Planning and Liaison at the SBA, to come and share with all of us on the new implementation of the new small business regulations that have been promulgated as a result of the Small Business Jobs Act and the National Defense Act. So, very excited to have Ken here. Ken, thank you so much. Welcome to HHS.
Thank you very much.
All right.
Good to see you.
Thank you, Ken.
I'm going to talk about today the process of how SBA goes about implementing legislation or regulations to establish small business policy, and that's the responsibility of my office. The way it generally works, though, I'll just say up front, is SBA does a proposed rule, gets public comment, then does a final rule, and then subsequently we submit that final rule to the FAR Council to implement in the FAR to the extent it needs to be, and they do the same process with the proposed and final generally. The first thing I want to talk about is the multiple award contracting provisions of the Jobs Act of 2010. Now, even though it's a 2010 law, SBA did not come up with its final rule until 2013. So it took approximately 3 years for SBA to come up with the final rule setting forth the policies. But for this particular one, the FAR went ahead early in 2011, I believe, and implemented it in sections 16.505 and Part 19 and also in Part 8.4 to specifically allow set-asides of orders and things like that. So that's one of the rare exceptions where the FAR Council did something first, kind of in a bare bones way, and then we came along later. I'm also going to talk about some of the other rules later, but I'm going to start with multiple award contracting. And so basically what this rule does is implements legislation that allows for total set-asides of multiple award contracts, partial set-asides, reserves of multiple award contracts, and then setting aside task and delivery orders under full and open or reserve kind of contracts. And here are some of the citations to our rule if you're interested. So the total set-aside is similar to any other contract. And basically, our guidance is that the Rule of Two will apply. You know, the shall part of the FAR will apply when you're doing your analysis. And we want you to do the parity analysis first. So we want you to consider first hub zone, women-owned, 8A, service-disabled veteran when you're doing your market research before you go to small business. And that's part of our parity analysis. Some of the things we got based on comments were situations where we may need to start considering doing on and off ramps for our multiple award contracts, especially if they're long-term, 10 years or more. You're going to have firms that are required and have to recertify as large, or they may grow and have to recertify prior to the 6th year, and you're going to want to be able to add in small businesses to help perform those services or provide those goods. Under this kind of scenario, if it's a total set-aside, you would compete your orders among all the awardees. And because it's a total set-aside, the typical limitations on subcontracting and those kind of rules will apply. And then we added in, at the request of some agencies, the discretion to require limitations on subcontracting on an order-by-order basis. Basically, under our principles, the basic premise is you do it on the base period and then each period afterwards. They have to comply with those limitations. That's how we set it forth, but we, at the request of agencies, did give agencies the discretion to require it on an order-by-order basis. So that's a total set-aside, so I think we're all familiar with how that would work. The more interesting part of the multiple award contracting rule is the partial set-asides and the reserves. The way I think of it, you know, a partial set-aside is you can't do a total set-aside. You've done your market research, and there's just some things that you don't believe that the small businesses can do, or that you can set it aside anyway. So when you've made that determination, you can still break your procurement down into specific things, CLINs, SINs, functional areas, whatever you want to call them, categories, where small businesses can do that kind of work, and that's where you would do a partial set-aside. And so when you do that, then once you've done the set, if it's an order that's going to be under that CLIN, SIN, functional area, or whatever you want to call it, that's when you would compete them only among the small businesses in that CLIN. And we also wanted to make sure that small businesses also have an opportunity on that same multiple contract to also participate in non-set-aside orders if they're capable of performing those. A reserve is where you've done your market research. Basically, you can't do a total set-aside or a partial set-aside, but you do want to make sure that small businesses get on the contract. You want to make sure that there's some avenue that there's going to be small business participation in your multiple award contract, and that's when I think you would do a reserve. And basically, you can then later on, if you choose to do so, set aside particular orders for those small businesses that you've reserved for. We've also specifically said that where there's only one, you can direct award orders directly to that small business. So it's a way to make sure that they can participate, but it's not real specific as to how they're going to participate. It's kind of up to you later on to decide, are they just going to compete for every order with large businesses, or are you going to set aside some of the orders for small businesses? So there's a lot of discretion in this rule. One of the specific areas we wanted to address was the requirement, basically how you assign a NAICS code to these multiple award contracts. The general rule for a contract is you pick the NAICS code and then there's a size standard that corresponds to that for your contract. You pick the best one, the one that best represents what you're trying to buy. It doesn't have to be perfect. There can be more than one that you can consider, but you just pick, basically as the contracting officer, you pick the best one. That works well for a single award contract, but sometimes you have these multiple award contracts where you're going to have CLINs or SINs or discrete areas that different kinds of services or goods. And in those scenarios, that's fine, but we want to have each one of those have a different NAICS code and size standard, because a small business can be small in one industry and large in another. We have size standards that go from 7 million in revenue to 35 million in revenue. We have size standards of 500 employees to 1,500 employees. And those are vastly different sizes of business. And we've looked at each industry to set a size standard that represents what a small business is for that work. So we want to make sure agencies are actually properly classifying their contracts to make sure that the small businesses that are performing are really actually small. And then we do want to have each order have a NAICS code so that we, again, are ensuring that the small business credit is flowing based on the actual status of the firm, that they really are small for that particular type of work. So basically, some of the basic takeaways I think you should think about are, when you do set aside an order, we want the same limitations on subcontracting and the same non-manufacturer rule type things to apply to that order, because you're basically, whenever we give a preference to a small business or a hub zone or any other type of business, in contracting, we want to make sure that that firm is actually performing some of the work to make sure that the benefits flow to the intended recipients. When you have a total or partial set aside, basically, where you measure how they're performing and whether they're meeting the performance requirements I talked about is each contract period. So over the whole, for example, if it's a 5-year 1-year contract with 4 1-year options, we would measure that first base year. Are they meeting it? They don't have to meet it on an order, every order, as long as collectively over that base period, they're meeting the performance requirements. But as I mentioned earlier, as a contracting officer, you do have the discretion to go ahead and make that, establish it for each order on an order-by-order basis. For a reserve, all that's done is make sure the small business is on the contract. So those performance requirements aren't going to apply to that small business because they're not, they're competing against large businesses potentially for orders, and the large businesses don't have any performance requirements, so the small would. The only time that would kick in again is if you actually set aside a task or delivery order for the small business. And then we still have some protections for the 8A program where a district director can waive some of these performance requirements as long as they comply over the life of the contract. And that's kind of in the 8A regulations, how that process works. We specifically wanted to address agreements, basic, blanket purchase agreements and the like. And basically, because these are not contracts, we have kind of a two-pronged approach to this. First, we will, if you set aside a BPA, we will determine size, based on the time of their quote or offer or whatever you want to call the response to that solicitation for the BPA. But because that's not a contract, we also want to make sure that they're actually small. In order to get credit, they have to be small at the time of the award of each order, basically. So because in those contexts, the order is the actual contract. And so in order to get credit, that firm still needs to be small at that point in time. And we specifically address how we're going to get self-representations on orders. You know, basically under the way this is set up, when you do a set aside of an order, you do not have to request size certifications with that order, okay? The status for the contract would still govern whether that firm is small or not for that particular order. But you do, as a contracting officer, have the discretion to request it on each order. And if you do, then that's how we'll go from there. We will determine size, you know, based on their representation for that particular order. It won't flow from the contract. But that's only as a contracting officer if you request it. And I give you some of the citations here in case you want to look up the rule. This is from our regs, 13 CFR. We clarified some other things in this multiple award contracting rule. First of all, recertification is now going to apply to program status. Back in the 2000s, 2007, I believe, SBA came out with a rule around recertification where basically if you're acquired as a small business or you grow, at some point you're going to have to recertify and your status for that contract is going to change. That rule only dealt with size, but now our rules are going to, and I gave you the sites there, if your status changes, if you're in a long-term contract and your status has changed, you're no longer a hub zone, for example, you're no longer service-disabled veteran owned, what have you, you will have to recertify as a company to this contracting officer, and the contracting officer will have to update that in the FPS to make sure that the credit is changed. We clarified some things around, you know, our rules require recertification for mergers, acquisitions, and things like that, so it applies to both the acquired concern and the acquiring concern. And then we specifically said that we don't think you should be able to do cascading evaluation where you initially set it aside and you say, well, we're only going to look at 8A, and if we don't get enough 8As, we're going to look at health zone and so forth down the line. There are a lot of complicating factors that I'm going to get into later as why that's probably not a good idea, and it wastes a lot of resources. You know, you need to do your market research and make a decision as to whether you're going to set aside for a particular type of small business. We also clarified some of the issues around a certificate of competency, which is under the Small Business Act, when a firm is found to be non-responsible, a small business, and they are found by the CO to be non-responsible, the CO is required to refer that to the SBA for a certificate of competency review. So what we said in this rule, for example, is that when there's a non-responsibility determination being made in connection with an order, you still have to refer it to SBA. Now, obviously, under a contract, if you've already found them to be responsible, you don't necessarily have to do a new responsibility determination for an order, but if you choose to do so, we will process that COC. We also added some clarification on COCs based on GAO case law, where GAO has said that when you do an evaluation based on responsibility type factors, and you do it on a pass-fail or go-no-go basis, that is something that has to be referred to SBA for a COC. On the other hand, if you use those evaluation factors that are responsibility type factors, and you do a comparative evaluation under GAO case law, that does not require a COC referral. So depending on how you set it up, may trigger whether or not the COC will be required. And then we specifically say, again, if a firm is found to not be able to meet definitive responsibility criteria, under the GAO case law, it still has to be referred to SBA for a possible COC. We specifically wanted to, in our rules, make sure that we're covering all the contracts. So we believe that this rule on multiple award contracting applies to multiple award schedule, and we want to make sure that it applies to orders and everything else. We want to make sure small business is a consideration whenever you're doing multiple award contracting, either at the contracting phase or at the order phase. A lot of these questions that we've had around this rule come up about, and I'm going to address now, are, what is the PCRs role? Do they review? What does the CO have to do when they're considering whether to set aside an order? And so some of these slides have quotes basically from either our rule or the Federal Register, so you can kind of read how we considered the comments and how we came up with our strategy. But basically, we want our PCRs to be able to look at all procurements, and that includes orders. So If you're not setting aside a task order, the PCR, we think, has the right to review those kind of things. Now, obviously, the PCR has to work out with the agency what they're going to be reviewing and what they're not going to be reviewing, because we only have so many PCRs and there's millions of contract actions. So that's done kind of on an individual PCR agency basis. But under this rule, we reserve the right to be able to review your decision not to set aside a particular order for small business. And the further thing we wanted to clarify is, even though the decision to set aside an order is discretionary, because the statute says that the contracting officer may set aside the order, whereas the FAR, Part 19, says shall set aside, we do want you to consider whether you can set aside the order for small business. And we do want you to document the file as to why you did not set aside. Same with the other things we provided, such as partial set-asides and reserves. We're asking the CEO to consider it, and we're asking them to basically just document the file as to why they don't set it aside, why they did not take that avenue. We did get some questions around if you've already done for example, a set-aside contract, can you further do set-asides within that contract? For example, you did a small business set-aside, but now you want to set aside orders just for HubZone. We basically said, we don't think that's a good policy. Basically, once you've set it aside for small business, we want everyone who was able to win a contract to be able to compete for that contract. When it's a large business versus small, we're certainly happy to set aside orders just for small business. But once you've done some type of set aside, we want everyone who can play for that contract to be able to compete for those orders. So these are some citations and quotes from our Federal Register final rule, where we kind of explained why we did what we did. We wanted to make sure that agencies were aware that you should consider everything. We're not going to tell you how to do it. We're not going to tell you have to do partial or reserve or orders. You know, the statute said may, so you do have a lot of discretion, but, you know, we want you to make sure you consider all your avenues, consider your goals, consider your, you know, obviously the needs of the agency when you're using these authorities. You know, when you utilize it, we want to make sure, as I said, you consider your goals, you know, you expand the file, and we want to make sure that there's something in the file evidencing that you did consider it and a rationale as to why you did not do something if you just choose not to use it. Again, these are kind of our explanation in the Federal Register. We didn't believe that the requirement to consider or document the file really was new. We thought that based on various FAR provisions, which I provided here in citations, it's always been kind of the CEO's responsibility to consider small business when they're going to either award a contract or place an order. And again, more citation to the FAR, and this is from our preamble to our rule, basically saying, you know, we don't think this is new. When you don't do a set-aside, you should consider, you know, you should document the file as to why you didn't do a set-aside. And we got a lot of comments from agencies saying that, you know, and from the public saying that we don't think this is very burdensome. It's kind of part of what they're supposed to do. We did consider other things, though. There were some that wanted to do things like requiring the posting of the rationale online, or a requirement to have a higher level of approval, or basically if you didn't meet your agency's goals, maybe you should be required to set aside task orders or delivery orders for small business. All those ideas were considered, but ultimately, you know, SBA makes its rules in consultation with OFPP and GSA and DOD and all the agencies, and, you know, basically we left it in a very discretionary, you know, you do have a lot of discretion. The basic requirement is we want you to consider it, and we want you to document what you decided and why you decided it. Under the FAR, again, a lot of these sections, as I mentioned earlier, have already been amended to some extent, not to implement the rule that I'm talking about, but just to give you the authority to do set-asides of orders and to consider small business. And this is from FAR Part 8. So that was multiple award contracting, and we can talk about, we can do some questions. If there's any questions like that, we'll be taking those online, and then we'll be discussing those at the end. I'm going to move on next to subcontracting. Later on, I'm going to discuss some of the NDA provisions and other things like limitation on subcontracting and a protege, but this was another Jobs Act rule from 2010. I've given you some of the citations here of where the sections are in the Small Business Act, and then also here's the citation to our proposed rule, and then our final rule, which was effective August of last year. And the basic thing behind this rule was statutory provisions around the prime having to notify the contracting officer if they fail to pay the sub within 90 days, basically when the sub is complete performance and the prime has been paid by the government. Another requirement that the prime notify the contracting officer when the prime used the sub to prepare the bid or offer, but did not use that firm in performance. Further, the contracting officer is supposed to consider both these things when they're evaluating how that large business performed on the contract. And there's a specific statute that says that a prime contractor with a history of late payment to its small business subs may be reported in FAPIS, the Federal Awardee Performance Integrity Information System. And again, these are the statutory provisions that subcontractors asked Congress for based on how they perceived that they were being treated by large business prime contractors. And for example, the 90 days, that is the statutory timeline. So basically, this is a direct, that's what Congress defined late as, it's 90 days. We did in this rule, and here's a citation, we did define what the subcontracting base is in case that's an issue for you. This is not all inclusive, but we wanted to try to talk about some of the issues we've seen over the years and define it. We specifically, in our rules, said that the Small Business Act requires you to set up your subcontracting goals as a percentage and as the total dollars of actual subcontracting dollars. But we also specifically said that you can, as an agency, set up your goals as a percentage of total contract dollars. Because there were some reports where GAO said, well, this prime contractors showed 100% of subcontracting dollars going to small business, but they only subcontracted $1,000 on $1 million contract. So it made it look like they were doing much better than they actually were. And so this is one of the things that we did to try to help give contracting officers the discretion to do this if they so choose, set it up as in terms of that overall value to contract, how much of that will be subcontracted to small business. This is a rule that is final as far as we are concerned, but now our subcontracting rule will be going to the FAR Council, and they'll be implementing these in the FAR in the near future. We specifically were asked whether we were going to define what it means to have a history of unjustified, untimely, or reduced late payments. There was arguments to leave it in the discretion of the contracting officer. There was arguments that we should define it, and so we ended up defining it. It's basically 3 occasions within a 12-month period. We specifically were asked whether we needed to address the fact that in a lot of subcontracts, the prime contractor will in the subcontract itself, will prohibit the subcontractor from discussing anything with the contracting officer. Well, that would be a big problem if the victim here, which is the small business subcontractor who's not being paid or not being used in performance, if they were not able to let the contracting officer know, that might be a problem. And so we specifically said that the contractor may not prohibit a subcontractor from discussing any material matter pertaining to payment or utilization with the CO. We specifically said in our rule that, and this is not new, this has always been in our rules since I've been in SBA, the subcontract is supposed to have a NAICS code and a corresponding size standard that best describes the principle and purpose of the subcontract. Just like a prime contract, your subcontract needs to have a size standard. That's how we measure whether you're in fact subcontracted to a small business or not. We specifically were asked to address, may a prime contractor rely on the subcontractor's self-certification, made in SAM? And we said, well, yeah, I guess you can. We're going to allow that as long as there's some kind of representation from the small business subcontractor basically saying that I verify that my data in SAM is correct, just like they're supposed to do when you go for a prime contract. You verify that your information in SAM is correct and accurate and complete. But we specifically also were asked not to allow primes to require their subcontractors to register in SAM, because some firms want to be subcontractors only and don't want to be in SAM, and don't want to give their banking information, for example, and so forth. So you can't require it, but if they are in there, you can rely on it. This is more from our general rules that have been around. Basically, we do want prime contractors to treat these small business competitions, if they have them, kind of like a prime contracting competition where you give a notice, because we do have a process where you can protest the size of a subcontractor if there is an actual competition. So these are rules that have been around, but I'm just pointing them out to you as part of my update on subcontracting. This is basically the language that we're talking about. As a large business, you have to represent to the government that you're going to make a good faith effort to acquire the goods and services from the small business that helped you prepare the bid proposal. And so we're going to get into, on the next slide, what that means. I mean, responding to a request for a quote is not the same as helping prepare a bid proposal. So we specifically asked for comments and came up with some kind of guidelines of what we mean by helping prepare the bid proposal. First of all, did the large business prime reference the small business in their bid proposal? Was there a subcontractor agreement in principle, a written document that shows that you were intending to use that small business to help with performance? Or did the small business draft any portion of the bid proposal? Did the large business use the small business's pricing or cost information, technical expertise, and the like, with an intent that they would subcontract? So that's kind of how we define what it meant to be used in performance. And then this is further language around what it means to be paying your sub late or paying them a reduced price. The statute basically says 90 days. Reduced price is defined here. And basically, as a prime contractor, you're supposed to notify the CO if this happens, and then you can provide whatever explanation you have around that. Obviously, a lot goes into this, including the fact that the small business has performed and things like that. So if there's an actual dispute between the prime and the sub as to whether performance has occurred or was satisfactory, that's a legitimate reason not to pay a sub. We specifically were asked to address some scenarios that come up from time to time. We want you to, as a contracting officer, update the subcontracting plan when you exercise an option. Review it, see if they're complying, see if it needs to be raised or lowered. And then when an agency or contracting officer modifies a contract to such an extent that it was below the threshold where you have to have a subcontracting plan, and they raise it to now it's above that threshold, we want the subcontracting plan requirements to kick in. We don't want agencies to be able to avoid their subcontracting plan requirements by, awarding a contract with one value and then subsequently modifying it and going above the threshold. I think it's $650,000 and then $1.5 million, I believe, is the threshold where a large business has to provide a subcontracting plan with that contract. We specifically were asked to enable contracting officers in their discretion to require a subcontracting plan if the firm goes from small to large during the course of that contract, so that you can now require that from that business that used to be small that's now large. You can now require one in your discretion. And then, of course, we had to address how that works in terms of reporting. And so there's more language in our rule that I have here about how it affects your overall reporting for subcontracting plan compliance under that contract. We specifically were asked to come up with some ideas, some discretion that we can give the contracting officer in terms of evaluation factors and considering subcontracting in evaluating someone for a contract. And so some of the ideas that we have, of course, is how you're proposing to do subcontracting on the contract. That's fairly standard. Consider how, to the extent to which the prime large business met their subcontracting goals under prior contracts. That's always a good consideration. We also want to introduce the idea of perhaps considering the extent to which the prime, paid their subs timely under their prior contracts, or whether we can have some kind of commitment that becomes part of the contract that the prime will pay subcontractors within a specific number of days. So some kind of competition or evaluation around getting payment to subcontractors more quickly and making sure that that's in writing and part of the contract. And again, this rule will be implemented in the FAR, hopefully in the near future. We also, under this rule, set up a policy basically to address getting credit for subcontracts. Right now, when you, as an agency, issue an order under another agency's contract, for example, such as the GSA schedule, you as the funding agency get credit for that at the prime contracting level. But any subcontracting credit for small business does not go to you as the funding agency. It actually goes to the contracting agency under the current system. So we set up a policy here that will allow credit to flow, for subcontracting to the funding agency. But of course, this is the policy. It still has to be implemented in the FAR, and we also have to change the systems to allow this credit to be properly allocated from the contracting agency to the funding agency. So it's something that we would agree should be the policy. It's just not yet implemented, and it will be hopefully in the future. Again, there's been a lot of legislative action around subcontracting. Most of that rule I just discussed was from the Jobs Act of 2010, but there's been further legislation around subcontracting. This is from the NDAA of 2013. Basically, there's a feeling that small business subcontractors are being named in proposals and bids, and they're helping that large business win the contract, and then they're not being used in performance. And I mentioned that earlier. Well, this is another thing that basically says you have to provide notice to that small business before you can use their name or refer to them in a bid or proposal. So it's further legislation that will have to be implemented in rules now to make sure that contracting officers are aware of these requirements. Then there's further legislation. This is the National Defense Authorization Act of 2014. Basically, there's been this idea for many years around lower tier subcontracting credit. Generally speaking, right now under our system of subcontracting and subcontracting plan reporting, you basically report only at the first tier. That's where you report whether you're awarding, what percentage you're awarding to small businesses and so forth. Under this legislation, there's a directive basically, if there's a subcontracting plan, to start allowing lower tier accounting to lower tier subcontractors that are small to also count towards that. Again, this is a statute, has not been implemented in a reg, and then once we even do that in a regulation, we're going to have to adjust the system to make sure that the credit properly flows, make sure that there's not double counting and so forth. So it's something that's coming. We're aware of it and going to be working on it. How quickly it gets done is an open question. So that was subcontracting. So I've done multiple subcontracting. I'll just briefly mention another big part of the Jobs Act was these size and status integrity rules. There's a lot more emphasis on making sure that firms that misrepresent their status don't get away with it. That the benefits of our programs at SBA actually flow to the firms that we want to benefit from it. So one of the new tools is the presumption of loss equal to the total amount of the contract where a firm misrepresents their status. In years past, if someone misrepresented their status for a contract but they fully performed, the procuring agency may not care because they got the full value of whatever services or goods they bought, and they really may not care as much about whether the firm really was a small business or a hub zone or a woman-owned business and so forth. But at SBA, we certainly do care. So this is a new tool that prosecutors can use to help deter and prevent fraud and misrepresentation of status. There's new laws around deeming, just submitting an offer to be a deemed certification where you could be at risk. We were directed by Congress also, though, to come up with ways to limit liability. There can be unintentional errors, there can be technical malfunctions and so forth. So we did have some rules around that. But basically right now, for any type of program, there can be debarment and suspension. We've done a lot of that lately for firms that are misrepresenting their status to get contracts. There's civil penalties and there's criminal penalties. So there's a lot of possible tools now to hopefully prevent, fraud and wrongdoing and misrepresentation in the small business arena. Now I'm going to briefly turn to the limitation on subcontracting. I'm going to go over where we are now, and then talk about some of the new laws that came along, and then talk about our implementation of those laws. So basically, this is the basic clause from FAR 19.508. It basically says, in any small business set-aside contract, you should insert the limitations on subcontracting clause, which is 52-19-14. This is a clause in a contract, just like all the other clauses. It's really the responsibility of the contracting officer to be aware of compliance. They should be aware that there is a performance requirement, that when you award a small business set-aside, the performance shouldn't be being done by a large business. It shouldn't all be being done anyway. I'll get into the percentages and how that breaks down, but you need to be aware that some of the work needs to be done, generally speaking, by a small business on a small business set-aside. So I'm going to go over where we are right now, because these are still in effect. This is still what the FAR says. This is still what our regs say. Basically, for the service contract, you have 50% of the cost of the contract for personnel with its own employees. For manufacturing, it's 50% of the cost of manufacturing. For general construction, we have a 15% requirement, and then for specialty trade, less heavy construction, the requirement is 25%. Of course, there are some differences among the programs. Right now, under the current rules, in the service-disabled veteran-owned and hub zone programs, if you do a set-aside, a subcontractor that's similar, that's a hub zone or a service-disabled vet, depending on what type of set-aside you use, they can count towards that 50% or 15 or 25, depending on which one applies. They can count towards that. Hub zone also has a much higher construction performance requirement, about 50%, and then a requirement that the prime do 25 or 15% of that respectively. And so I provided some of the citations here for both our regs and the FAR on these kind of limitation on subcontracting rules. So for women-owned set-aside or for 8A or small business, the prime must meet those performance requirements I talked about earlier. Okay? A subcontractor does not count towards those performance requirements right now under the current rules. And then we do have a requirement that when you have an 8A joint venture, that when they're performing an 8A contract, that they're reporting to SBA on how they're meeting these limitations on subcontracting. Now, everything I just talked about will change eventually, because under the NDAA of 2013, they changed the rules and basically said they changed the calculation from cost incurred and things like that to amount paid. And they also basically said that in all cases, in all programs, we want the performance by a similarly situated entity that's a subcontractor to also count towards those performance requirements. So eventually, all the programs will be like hub zone and service disabled are right now, which allows similar subcontractors to count towards that performance requirement. We are working on a proposed rule to implement this, and it should be published sometime in, I'm hoping that sometime towards the end of the month, there'll be a proposed rule out there for public comment on how this rule should be implemented to implement this legislation. I've also provided a cite to a case from GAO there that may be complicating things to some extent. It's called C-Lift, and basically in that case, a unsuccessful bidder protested and said that the winner couldn't comply with the limitation on subcontracting. And GAO denied the protest and said, well, even if the prime contractor can't meet the performance requirement, they were subcontracting to a small business. So under this new law, subcontractors count, and therefore, we deny the protest. This is in a footnote in this case. But people have read that, and some agencies have started to implement these changes to NDAA, even though they're not yet in our rules, and even though they're not yet in the FAR. That's a decision, I guess, that a contracting officer has to make in consultation with their lawyers, around whether they're going to use the FAR, whether they're going to try to get a deviation, whether they're just going to put it in the solicitation and see if anybody protests. If no one protests, then that, generally, if it's apparent on the face of it, you don't protest, then you're allowed to use those things. Our concern is making sure that we define what we're talking about, make sure you use the amount paid and what it means to be similarly situated. So My advice has been to agencies is to wait until we do our rule and gets implemented in the FAR, but there may be agencies out there based on the CLID case that are going to be more aggressive, I guess, in trying to use these new laws from NDAA of 2013. We also were given, under the Jobs Act initially, and then again under the NDA of 2013, the authority to establish a mentor protege program for all small businesses. Right now, at SBA, we have a mentor protege program for the 8A program. It's been around since around 1998. It allows an 8A participant to enter into a relationship with a large business or any size business, and then if they're approved by SBA, they can joint venture on contracts as small businesses. They can go after 8A contracts, they can go after small business contracts. Now we have to figure out at SBA how we're going to implement this and create a program for all small businesses, not just certain program participants. And then the NDA of 2013 also directs us to take a look at, to basically draft rules and then evaluate the mentor protege programs of all agencies. So once we come up with the final rule, then within 1 year we'll have to look into, agencies will have to come to us, and then we'll have to evaluate their mentor protege programs. This particular rule is proposed, and it will be at the Office of Management and Budget on interagency review for several months. So I would not look to see this rule proposed anytime in the next 90 days or more. So it'll probably be late this year or early next year before you even see a proposed rule along these lines. And with that, I believe I am done. So we're going to now, I've given you my contact information here, phone number and email, and I think now we're going to see what kind of questions we have.